Nicole Carlton, Assistant Safety Director, and I am representing Director Drummond, who is out of the office. To my right, I have Assistant Director Jason Shackner, and to my left, I have the Chief of Police, Dorothy Todd.
Okay. So we're going to start with ordinance number. Let me see, do I have it up here? I don't have the piece of legislation. Okay. Okay. We got it. Okay, good. Okay. Let me get this. Ordinance number 228-2025 by council members Polensek and Griffin by departmental request, an emergency ordinance to amend section 630.01 and 630.02 of the codified ordinances of Cleveland, Ohio, 1976, as amended by ordinance number 574-18, passed May 14, 2018, relating to criminal activity, nuisances declared, an action to abate the nuisance and cost of enforcement. This piece, the first time reading on this was February 24th. And again, to the viewing public, when we say first time reading, that's when it's read before City Council, and then it goes on to review by the various departments of the administration. It was approved by Director of Public Safety, approved by Director of Finance. There's no legal objection by the law department, and the legislation now is back before Cleveland City Council for proper discussion. This legislation was initially passed in 2018, and I know because I was a co-sponsor to the original piece with then Councilwoman Donna Brady pertaining to nuisance. So at this time, Assistant Safety Director, would you care to explain what your team and the chief, what you're proposing to do here?
Thank you to the chair. If approved by council, ordinance number 228-2025 would amend sections 630.01 and 630.02 of the codified ordinances relating to criminal activity nuisances declared and action to abate nuisances and cost of enforcement. The following summary outlines the proposed amendments to sections 630.01, criminal activity nuisances declared, and 630.02, action to abate nuisances, cost of enforcement to strengthen the city's ability to address and abate nuisance activity. The purpose of the changes, the goal of these amendments is to ensure that effective action can be taken against properties associated with repeated nuisance activities that threaten public safety and quality of life in our neighborhoods. The key amendments: probable cause determination clarifies that an arrest or citation is not required to determine probable cause that a nuisance activity occurred. Explicitly states that police personnel may rely upon witness statements. Expanded definitions introduces, quote, persons associated with property, end quote, to enters, patronizes, or visits, or attempts to enter, patronize, or visit, or waits to enter, patronize, or visit a property or person's presence on a property, including any officer, director, customer, agent, employee, or independent contractor of an owner. Expand the list of nuisance activity now includes all drug offenses under Ohio Revised Code 2925, equipment and safety violations under sections 437.19, horn, sirens, and warning devices, and 437.20, muffler cutout, excessive smoke, gas, or noise of the codified ordinances. Reckless operation offenses under section 433.07, street racing, stunt driving, and street takeover prohibited of the codified ordinances. Key amendments to section 630.02, action to abate nuisances, cost of enforcement, title updates, changes references to, quote, Cuyahoga County Auditor, end quote, to, quote, Cuyahoga County Fiscal Office, end quote. Nuisance declaration process adjustments. If 3 or more nuisance activities occur within a 6-month period, the Director of Public Safety will issue written notice warning that the property is at risk of being declared a nuisance. The property owner must submit an abatement plan within 10 days. Failure to do so results in a $100 a day fine until a plan is submitted. The director has the discretion to declare the property a nuisance if another nuisance incident occurs at least 13 days, but no more than 6 months after the notice. The updated language provides flexibility for the director to assess the legitimacy of reported nuisances, to prevent individuals from abusing the system, and to not discourage property owners from reporting criminal activity that is occurring on their property.
Okay. Again, to the viewing public, this legislation was worked on in 2018, and because of what we want to call what many residents would refer to as the house from hell or the neighbors from hell, where we were having constant problems with disorderly conduct, police activity, barking dogs, kids out in violation of the curfew law, you name it. But we then expanded it as well to incorporate, commercial businesses where we were having complaints as well. So what I'm trying to understand with your proposed changes or in fact, I don't think there was any. Where's the amendment sheet? Let's see an amendment sheet in here. Okay, so there is not a. Yeah, there's not a separate amendment sheet. It's all underlined in the, if you go to the, where the legislation is. So who else Chief, would you care to comment on this? The sergeant's not here who is,
To the chair, Sergeant Lanton is on his way. He'll be
Okay,
here shortly.
because let's talk about, part of the challenge that, because I send out the letters. I sent out the letters to landlords. In fact, I just sent one out last week to a landlord of a derelict property in my neighborhood. But what I'm trying to understand, and where I think the breakdown has been in the past, is that the council person or the neighborhood group or neighborhood residents, we turn it in, and we know that within 3 times within a 60-day period.
Yes.
After that point, that property can be declared a nuisance.
Correct.
But we found that that's where the breakdown was, that the property owners were not being notified. The property owners were not being notified. And then continued complaints, they were not getting the letters. And again, it has no bearing on you folks, but under the previous leadership and under the previous safety director, so few notices went out. It was just not very reassuring to any of us that the nuisance laws were being enforced. So what I want to hear from whoever, maybe it should go to the chief. How are we going to be guaranteed that the nuisance laws in the city of Cleveland will be enforced, and that the safety director's office will take the appropriate action against the landlord, and that because no one could ever tell me if there had been any action taken with Cuyahoga County as it pertains to the $100 fine being placed on taxes. Nobody could tell me that. So does anyone know if that was ever done? Do we know? Sergeant, come on up to the table.
Yeah, to the chair, I have Sergeant Reginald Lanton coming to the table now to discuss.
Yeah. Sergeant, introduce yourself to the viewing public.
Sergeant Reginald Lanton, badge 9247. I work for the director.
Thank you, Sergeant.
Yes, sir.
So we started the discussion. We're trying to find out, do you happen to know, and educate, you're relatively new to this position, correct?
5 years. So.
Yeah, okay. Because it was Sergeant
Diane
Chanko.
Chanko.
Yes.
Sergeant Chanko.
Do you happen to know, Sarge, how many homeowners were actually received the assessment? Do you happen to know?
I don't have a specific number. It's been well over a year since we've reached that point, but we have sent letters of assessment to license and assessment to enforce the penalty.
Now, but educate me. Do we enforce that, or does it go over to the county, be placed on their taxes? Because that was our intent, was that went to the county.
To my understanding, that was in-house, license and assessment.
That was
took care
handled
of that,
in-house.
yes.
Okay, who can comment on that?
Through the chair.
Yes. Identify yourself again for the viewing
This is
public.
Director Jason Schachner.
Okay.
The procedure that is laid out in the ordinances is that at first, a fine is levied, and I think internally it goes to, of course, the divisions of
Yes.
assessment and licenses. Now, if that is not paid, at that point,
Yes.
it would be attached to the
That-
tax duplicate.
Do we know how many of those ever took place?
I do not know.
Yeah, that's something we need to know.
Okay, you can find that out.
Because we know, we sent out the initial. Can someone tell, let's just say on a $100 fine, the initial one, do we know how many paid that?
No, sir.
Do not have that information.
See, again, we thought by creating that, Donna Brady, myself, and a few others, that we thought that we would get the attention of the landlord. Because so many of them don't care unless they have to pay. You know, they don't care who they rent to, they don't care what their tenants do. But when it starts hitting them in the pocket, then we find it, then they start paying attention. So I'm going to make that request through staff, through, if you can tell us, provide to us, let's just say in the last year, how many received the $100 fine?
To Chair the
Slash-
councilman,
yes.
if I can just speak, because you
Go
made
ahead.
mention about previous administrations. Obviously, Director Drummond, it's been a year.
Yes.
Part of when he came in was looking at this. We had lost the ability for tracking, and this was a IT type program that we used that was not feeding over the information that we needed.
Okay.
So when he came on, we had to develop a way to track the calls for service, and that took a little bit of time. At that point, Sergeant Chanko had retired, so
Yes.
we cannot speak to what was done in the past. And we know that there may not have been as many as we wanted to go out
Yes.
for assessments. So
Okay.
Director Drummond definitely looked at this. He's tasked Sergeant Lanton and staff to look at the ordinance itself and to make sure now we have a better way of tracking it. So we had to, get back on our feet again with tracking it and then providing the notice to the property owners themselves.
Okay, but
Sure,
but
I'm
see, but I have to say, but here's the frustration with us. We take time to put legislation together, and to the viewing public, council cannot hire, we cannot fire, we cannot deploy, we cannot administer. We're prohibited by law, and well, I have to continue to say that because I'm finding that so many of the speakers who come down on Monday night for public comment have no concept of that. They don't have no understanding how city council and the administration and city government operate. I'm just astonished to see adults stand up at the microphone and somehow look to the council to administer, and we cannot. And I keep saying maybe we need to put civics, maybe we need to put civics and government back in our schools so people can understand how this place operates. But so we passed legislation. We expect the legislation to be enforced by the administration. And how many times have you heard me say at the table, if there's something that's not working adequately, tell us so we can amend it, we can change it, we can adapt it. But we very seldom ever hear that. So that's why I'm appreciative today, because I've been talking to the director for a year about this piece. Because of the ongoing concerns that my colleagues have with regard to nuisance law enforcement. So you're telling us at the table with the proposed changes that you believe this will give you the ability, and so Assistant Director Schachner, you wanted to speak. Go ahead.
Thank you, Chair. I just want to call out one specific
Yes.
change, because previously it said in section
Wait a
630.01A,
minute. Look at 630 point what?
01A, the
01A.
very first one.
Okay.
And it's the third line, at least on my paper.
Okay.
It says, to be a nuisance activity, a criminal conviction is not necessary. That's all it used to say. We added, to be a nuisance activity, a criminal conviction, citation, or arrest is not necessary. There was some, it was a little vague and open to interpretation previously, that since it called out specifically that a criminal conviction is not necessary, that all other things may be necessary. So what would happen is, let's say police is dispatched out to a call for service out to the property. They get there, they didn't issue a citation, they didn't arrest anybody, but they just said, hey, you got to cool it. Stop with the noise,
Right.
stop with the activity. That wouldn't count previously.
Okay.
Because it was somewhat interpreted, and you can correct me if I'm wrong, that some sort of citation needed to be issued for it to count as a nuisance.
Right.
But we all know that you have that noisy neighbor and the police are coming out all the time. It gets frustrating that, oh, no citation's being issued. Why aren't they being charged civilly for this, through
Okay.
this method? So this allows that to occur now. Because we had something which I believe, what was it, W&S, that they call it?
WCS.
WCS, which, sorry, Sergeant Land, can you tell me what that stands for again?
WCS means the wearable camera.
Sarge, pull the mic right up in front of you.
Yeah,
Thank you.
it's on.
WCS means the wearable camera system that the officers wear.
Okay.
So their interaction with the complainant or the subject is captured on camera.
Yes,
Okay.
and then there's usually in the printout you would get in the report, it would say warned and sent or advised. Previously, there was a question, does that count as against a nuisance activity?
Right.
Because there was no citation, no charges, no
Right.
arrest.
Right.
Previously, because it only said that a conviction is not necessary, we're like, oh, maybe something more. But this clarifies that you could just talk to someone as long as you have probable cause that the nuisance activity occurred, that counts against the property as a nuisance
Okay.
activity.
So who specifically worked on this from the administrative standpoint?
I worked on it, Sergeant Lanton worked on
Okay.
it, Assistant Director Violin, and Special Assistant Mike Herb.
Okay, so you think you have touched on what you could call the critical, or where you thought there'd be deficiencies?
And
Correct.
I have one point to make as well. We have property owners who would call based on nuisances. And
Yes.
we didn't want to discourage property owners because I
Yes.
think Sergeant Lanton was issuing out some notices. Property owners call because they have individuals hanging out in front of their stores, and we encourage them, I know across with all the commanders.
Right.
If you have a problem in front of your business
Right.
to call. We
Yes.
did not want to discourage property owners from calling because
Right.
then they would get, basically
Yeah.
notified that they are being a nuisance, but they're the ones who called. So we want to make sure that, and this allows for that property owners aren't discouraged from calling when they have issues out in front of their businesses that they are working on trying to control.
Okay, and
Yeah.
that, I think that's a very positive move. To the chief, tell me how you envision this working from a standpoint. We get a call, citizens turn in a complaint, I turn in a complaint, I do most of my complaints by email, the commander of the 5th District. How do you envision seeing this working from your perspective and that of the CPD?
Yes, sir. So in the past, I haven't seen one of the updated letters.
Okay,
But what would happen in the past is the notice would go out to the property owner
yes,
and also to the district commander that where that property was. And they would advise to contact the commander to work out a plan and to address some of the issues. So when, in my time as the 3rd district commander, when I would get these letters,
yes,
a lot of times I would get a call from, the homeowner of a resident,
Right.
where they have tenants living there.
yes,
And they wouldn't be aware of the calls for service that were taking place. So I would go through the calls for service, explain to them, if it's a loud music issue or
Right.
a disturbance to the neighborhood. And I would try to work with them on how to, calm the situation for the neighbors. But there were some property owners that were just non-compliant to the nuisance complaints.
unfortunately.
So this will help the Division of Police with those individuals. We do have property owners, store owners who tried their best to be compliant.
Right.
And we would work with solutions on the law enforcement side, and we would give them recommendations of what
Okay.
changes they could make. And this gives more authority for consequences.
Okay, so how are you going to work the LLCs, which now in some neighborhoods are the predominant landlords?
To the chair, I just want to add something too before I get to that.
Okay.
What you stated previously about complaints coming from council when
Yes.
you talk to your residents that
Right.
come through. My understanding of how these nuisance letters get triggered, at least the process that has been in the past is a report is run every Monday, but it's based on calls for service, not
Yes.
necessarily letters that come from, so actual times that
Yes.
police were called out
Yes.
to a property. I don't know if Sergeant Lana can speak to how, and maybe in the future, that complaint letters from council members would be incorporated into that as something that needs to be investigated and counted as, because we would have to determine at that period of time, maybe it was a past period of time that something occurred, of whether we have probable cause that the nuisance activity existed. So there may be a little bit of a disconnect from the council letters coming through complaining of a property versus calls for service.
Okay,
when somebody calling
but then
the police.
if there's a protocol you wish to establish, then you need to tell us what that protocol is, because like this whole last week, I've been turning a location into the 5th District of parking, illegal park. I'm getting all these complaints from the street, illegal parking on the city land bank lot. And I mean, they tore this lot up. I mean, it's unbelievable what they did with the city lot, the tree lawn, the sidewalk. And so, you know, my complaints have gone right to the commander's office to get somebody out there to give out tickets or do whatever. This person who thinks they can just tear up this lot. So if there's a protocol or a form or something you want us to turn a process, then let us know. I just want to make sure there's no break in this. That I want this to work. We thought when we passed the legislation in 18, we had input again from our own attorneys. We had input from the administration, but our frustration was it wasn't being enforced, and nobody was coming to us and saying, "Council, this is what you need to change." So I appreciate Director Drummond and the administration stepping up to the plate, and the chief to look at the piece and come up with a better process. I want to make sure it's going to get enforced. So, Chief?
So, to the chair, a couple just items I'd like, to address. I encourage residents and council members, we all know which properties are the nuisance.
Yeah.
Keep the address in your house so you know, and call the police. It's helpful for us if you're giving the exact address of
Right.
the location, because it helps with the tracking portion. So then when we're looking at declaring it a nuisance, instead of using a corner or a house next to, or if you have the opportunity to safely have that address accessible, I encourage people, don't go out there and confront anyone.
Yes.
But if you have it and you know that problem area, keep the address handy when you call police. And always use the address as opposed to the red house,
Yeah, I know.
because it's really beneficial for our tracking.
Chief, I along with my colleagues, so often I'm saying the same thing. Don't tell us, don't tell the police it's the blue house halfway down the street. We need an address. But the problem is, a lot of houses today in the city do not have addresses on them. Why, I don't know. I have a prominent address on my house. I made sure my son across the street, up the street, has one. But a lot of houses today, even though there's an ordinance in within the city that you have to have an address on your home. You have to have an address that can be read from the street on your home. But that's part of the thing. It's never been enforced. So that's part of our challenge. But I appreciate that, Chief, and I hope to the viewing public watching this, again, please, if you see something, say something, has been said so often at this table and in council and by the administration and by the chief. We need to have their cooperation. So from the administration, any other comments before I call upon my colleagues for comments? Chief, I just want to say this. And do you believe the actions that you're proposing today are what you needed to make this more enforceable?
And to the chair, with these changes, I think it's going to help police a lot.
Okay. Councilman Slife. Wait a minute. Anyone else?
Chair, I wanted to answer your
Star?
question about the LLC.
Wait. Go ahead. Go ahead.
So the notice requirements to notify a property owner there's a nuisance, we listed a new process, which is that the notice shall be deemed properly delivered if sent by first-class mail to the owner of the record of the Cuyahoga County Fiscal Office. And if there's no name there, you put property owner.
So you're
And they'll
addressing
be-
the LLC issue.
Yeah, I'm addressing the LLC issue. So if they're listed as the property owner on the fiscal office, they're responsible. And when it gets to that point, they're required, and it's a lawful order for them to provide an abatement plan. If they do not provide that abatement plan within 10 days of receipt of that order, of that notice, then we could charge them $100 a day. And if they do not
Okay.
pay the $100 a day, that's going to be attached to the tax due.
That component is very important because that's when you'll get their attention.
Yeah.
Because right now, I can't speak to my colleagues on the west side, but virtually every rental property, what I'd call a rental property, or two-family on up, virtually everyone I'm looking at now in my own neighborhood is an LLC. And that's the challenge we're confronted with. So I want to make sure that we can address that problem, which is, again, a major problem on the east side of the city. Okay, anything else before I call my colleague? Councilman Slife, I have Councilman Slife, KZ, Starr, anyone? Okay, go ahead.
Thank you, Councilman, and you accurately described my property as the blue house halfway down the block. So,
Oh, you're where those
I'm not
parties
gonna
are at.
I'm not gonna read into that. I think there's still a missing component to this, and I'm gonna kind of describe it in, I guess, two anecdotes. Last summer, I was dealing with a property that had squatters in it, and I would call it a nuisance, but we did not go through the process of officially declaring it a nuisance because the property owner out of state, we were able to, thank you to the Pittsburgh, North Carolina Police Department for knocking on this guy's door, and honestly, Derek Brown, this was a CPOP of, saying the Cleveland police are trying to get in contact with you about your property in Cleveland. And lo and behold, I learned that our municipal court will not issue eviction notices for unnamed individuals. They won't issue a John Doe eviction. So essentially, this man out of state seeking to comply and get people who are trespassing on his property out of it was left with no recourse because he did not know the names of the individuals who were illegally occupying his property. Essentially, Mike Polensik could come back from vacation and I'm living in his house, and if he doesn't know who I am, we're telling him there's no recourse. So when I said I didn't go through the process of officially declaring it a nuisance, that's because we have a property owner who is seeking to comply, and declaring it a nuisance, asking them to abate the nuisance within a time period or be levied a fine is really kicking someone, in my opinion, while they're down because they are eager to comply. Another one that I'm dealing with potentially now is a situation where neighbors have been recurringly calling 911 about a problematic property. As I understand it, it is an up-down double. The owner has lived downstairs but is no longer occupying the downstairs unit because of the nuisance, is seeking and there's an eviction pending in housing court. But my understanding is that there have been times where housing court has not allowed evictions to proceed because, for example, someone was not in compliance with our rental registration law. Now, of course, I want people to comply with all of our laws in their totality. However, I certainly think, and I would suspect others would agree, there are situations where the need to abate the nuisance, sometimes through eviction, is a higher order need than a regulation pertaining to some other department. So I guess what I am wondering is within, I don't know specifically where it would be. I'm not an attorney. I just play one on TV. But I would like to find a way to allow a landlord to bring some sort of action in court waiving the other requirements of local law and maybe requiring them to So let's say that someone is not complying with the rental registry, that the court would not be able to say, you have to become compliant with the rental registry before we can proceed with this eviction. I think it would make sense if someone has a declared nuisance, rather than us going for them punitively, they are able to use the declaration of a nuisance to essentially demonstrate to the court the need to waive other requirements or have them adhered to retroactively so that the nuisance can be abated.
So-
That is to summarize all
Yes.
that. This is all good until we hit, I think, the court and the ability to abate all nuisances. Some will require court, and we have been hitting a roadblock there.
So are you proposing an amendment, Councilman? What are you?
I guess my question before, and I will say, I don't think that this is perhaps too complex for me to propose an amendment on the fly.
Okay.
However, I guess the first question would be, could the administration kind of speak to these scenarios? What these proposed changes seem to give us more teeth, but do the situations that I just outlined continue to occur regardless of whether this legislation passes with these amendments?
Okay. Who would like to comment?
I'll comment.
Okay. Assistant Safe Director Shatner.
Thank you. Through the chair to Councilman. This may not completely satisfy your question here, but it is a defense through the appeal process of the nuisance if one was actually, if a property was declared a nuisance. Of course, you could appeal it to the director, and then you could appeal it, if you don't like that answer,
Right.
you could appeal it to the Board of Zoning Appeals. One of the defenses is that they were complying with the requirements of RC 5321.17C and RC 5321.0489, which are both termination of tenancies or removal of tenancies. Terminating the tenancy, there is a difference, right? You could terminate someone's tenancy, but removing them from the property is the eviction process. So I believe it addresses the property owner's need of not being penalized because it's being held up in the court if they made the steps to cancel the lease or to terminate the lease. And that has been built in there. The other issue of the housing court not granting an eviction due to procedural or policy reasons within their own court is something that I think would be fairly difficult to legislate and would be more of a discretion of the court at the time. But that's something that could, of course, be researched and addressed through other legislation.
Okay. Who else from the administration? Chief, you have any comment? Go ahead.
So I have to agree with his comments. I don't know that we can tie our legislation to order the court to do anything. In simple terms, this is more of a public safety portion.
Yeah.
I don't know. I agree that it's, a needed option, but I don't know that we can make them comply with a directive from here.
So wait a minute. So I'm just trying to understand something because I know Councilman Slife has been looking at this. The rental registration provision connected to eviction, was that a legislative or that was an administrative action that the judge took? Do we know?
I believe it's an administrative action of she's requiring compliance.
She's requiring
Yeah.
compliance, and I can understand that. I can see that both sides, because if you're not complying with the codified ordinances as a landlord, but you brought up a very good point. If the landlord is not here, or went somewhere, and then all of a sudden there's squatters in the house, causing a problem, and I think we've all dealt, or the majority of us have dealt with squatters at one time or another, unfortunately. and I'm seeing some other cities across the country where it's become a major problem. I don't know how much of a problem it is, I guess, from one community to the other. So is there any other comments? Yes.
Briefly, through the chair.
Assistant Director.
The fix may be through the ordinance or the codified ordinance that discusses the rental registration.
Yeah.
That provides for either an expedited or some sort of exception to, or some clarification that not being part or not being registered as within the rental registry does not preclude you from evicting somebody from your property. If that change is made within that codified ordinance, I'm just assistant director of public safety. I'm not in the law department anymore.
Well,
but I would think that would be a
you
way.
bring up a very valid point, and it's something that I would encourage Councilman Slife and with our own attorneys and the administration, assistant law director that is here, that if we can take a deep dive on that one. I think what we're all trying to do, we're dealing with issues today that we've never had to deal with before, or maybe to the magnitude that we are. And we just want to make sure whatever action we're taking attempts to address the day in and day out complaints that council members are receiving and that our citizens are experiencing on their with a neighbor or somebody on their street as it pertains to quality of life issues. These are quality of life issues we're trying to address here as best as we can. Yeah. Councilman?
Yeah, so I won't, I'm not making an amendment, certainly.
Okay.
This is too complex. But I do want to have this deeper conversation because, again, you said kind of we understand we don't want people to flout our rental registration law and then kind of reward people for misbehaving. And we know that landlords have used in the past, or maybe incentivized to use John Doe evictions in a kind of a retaliatory, abusive way. What I'm trying to solve for is kind of the overcorrection where there are bona fide situations where I think a reasonable person would agree that there's something going on here, but in our effort to, safeguard the rights and the humanity of the 95% of people, where we're allowing these 5% situations to occur. And my thought has been, there's a difference between saying, I'm a landlord and I want to do a John Doe eviction because I'm a jerk, versus there is a declaration from the Department of Public Safety that this has met a threshold that allows this type of scenario to be considered. And again, and if necessary, I would be very happy with retroactive compliance. We're not letting you off the hook. Part of this is you have an X amount of period to satisfy the laws that you yourself were not adhering to, but understanding that, if we are requiring people to pause and satisfy the regulatory side of some of these things, the quality of life issues that we're trying to address are only being exacerbated during that time period,
Okay.
right?
Yes, Assistant Director.
Just one last point through the chair, the councilman. Then I believe the way you could approach that, and of course, the legislative arm does, if the courts do something that they disagree with, the legislative arm does have ways to codify things to prevent that from happening in the future. If you want to protect people that may have not been compliant with the law, but they're acting in good faith, and they need to evict somebody for the good of the community. It's not just personally, this would be good for that landlord. It would be good for the whole community if that person's removed. Then I believe that this council would have to propose in partnership with law department or whoever, an ordinance that provides certain guidelines that if you meet these thresholds or these things occur, then you can do a John Doe eviction that's permitted. Okay. Or if these things occur, then yes, you can do a retroactive registration in order to comply with the court's eviction policy.
Okay.
But again, the court could either accept that or not accept it, right? They could say, that's not good enough for us. I'm still not doing a John Doe. And then you're kind of at a standpoint.
The point of information, because I'm listening to this conversation, part of the issue is we do not have any definition of squatting anywhere in our charter. We don't have a definition. We don't have any guidelines. And so offering a suggestion, if squatting, if we see it's a problem, again, as a legislative body, it is our authority to create the rules and the processes.
Okay.
And then it is the judicials, the courts, then to follow what we have set out. And if there is a discrepancy between two branches of government, then you go from there. But the first point is you actually have to explicitly write it down, what's the process, and go from there.
Thank you.
So I would offer that. I mean, we need to actually create an actual policy. There's nothing in here that talks about squatting, the ideal of it, and that is the fundamental problem. So if the legislative branch wants a process for squatters and what that process and the penalties were, we need to create a policy.
Thank you.
Thank you.
Thank you. Okay, Councilman?
I'll let others chime in with this or anything else.
Okay.
But I do think that if we're trying to satisfy what this is seeking to satisfy, there's additional work, what Councilman House Jones just described, as well as maybe some other things that need to do this from kind of the entire sequence.
Okay. Thank you. Thank you, Councilman. So our challenge is going to be all of us to try to figure out how we define what a squatter is. And I have my own observation, my own opinion what a squatter is, but that's going to be working with our attorneys, working with the city attorneys to define that, and then maybe it helps the housing court judge, processing and prosecuting these cases and more effectively and efficiently. I have Councilman Casey.
Thank you, Mr. Chairman. Mr. Chairman, to the Assistant Safety Director, did I hear correctly in earlier testimony that you do not have the stats or statistics on how many citations or civil fines or whatever were issued under 630.01 and 630.02? Or do you have that information?
Are you looking for previous administrations?
I'm
or what
looking
time
for,
period?
I'm looking within the
Through the
last
chair.
3 years.
The last 3
Through the
years?
chair to the chief.
Through the
go
chair,
ahead,
please.
Sergeant Lanton.
Sergeant? There you go.
Councilman, through the chair, we do have those numbers. We track excessive use letters. We track declarations of nuisances. We do. But what we can't track is the fines that were levied.
We can, Mr. Chairman,
Yeah.
we cannot track the fines that are levied. Who levies the fines then?
License and assessments.
Okay, so we.
Through the chair.
Through the chair to the other side. So we can get it, we just have to get it through license and assessments, correct?
Through the chair to the councilman, yes, it would be the
Okay.
Division of Assessments and Licenses.
Okay.
And we would have to match up the addresses. I'm not saying we can't do it. It
Yeah.
would take us some time to gather that data.
And then, Mr. Chairman, to the
Yes.
Assistant Safety Director, if I heard in earlier testimony that the chair has been working with the administration for about a year on this piece of legislation, correct?
We've been talking. Yep.
Through the chair.
Right.
I believe we started working on this last November.
Okay.
If I remember correctly.
Okay, half a year, 6 months. So here's my frustration, Mr. Chairman, to the Assistant Safety Director, is we're here on a specific ordinance, right? You had to have known that question was going to come up. You're asking us to amend an ordinance, and what is very frustrating for me that I'm learning in just about every department that comes to us wanting to do legislation is that we don't know if it's even worth it. We don't, on this side of the table, we don't know if 2 letters have gone out. Are we doing this just to look good, just to sound good? We have no factual evidence that what is currently on the books is or is not working because we don't have the numbers or the statistics to back it up. You had to have known that question was going to be asked in regards to the number of citations that were coming up. And to come to the table, we don't know if it's even being enforced. The answer could be 0. Probably not. I mean, but how do we know that this is going to make this any better when we don't know what's happening currently?
Who would care to comment on that?
Through the chair, the councilman, I understand the frustration, and this revisions, modifications, amendments on the ordinance allows everybody, be police and our enforcement on our side, to have some better language, especially when it comes to property owners calling, to clarify some issues that we knew may have been some tweaks that were necessary, especially if the property owner is calling. Do we want to get after the property owner who was calling because he has a nuisance on his place of business, and then we're issuing him letters, and then he's saying, wait a minute, I called because I was instructed to call for issues. So we had to make sure we were providing clarification because we didn't want to send out notices to penalize property owners themselves. Looking at historical data, we can definitely give us some time to pull that up from previous administrations. We can pull that data together.
And Mr. Chairman,
Yes.
stop with the previous administrations. Okay, you're here, all right, and this is overly frustrating for me because, and I believe everything you're saying, but just because you're saying it, you're not coming prepared to the table to prove it. The stuff that this is going on, Mr. Chairman, in every committee now, right? I just happen to have this assistant commissioner in front of me, so I'm venting to you, right? But
Assistant Director.
Assistant Director, I'm sorry. But what's happening is we're here to talk about a specific piece of legislation. We have questions. Administration's not coming prepared, and then you're asking us to pass this, and then we get the information 2 days later, and we may have another question regarding it. When you come to the table regarding a specific piece of legislation, you should have the history. You should just know it, right? And Assistant Director, it's deemed toward you right now because we're here on this specific piece, but this is a growing frustration throughout every piece of legislation that we hear. How many times do we always have to get information after the fact? So you're asking me to vote on a piece of legislation that I don't know if it's working in its current state. You know, you're not able to sit here and say, we sent 100 letters out and only 40 responded, or this is the thing. It's frustrating. So you're asking us to do a feel-good piece of legislation, and we have no factual information about whether this is actually working or whether it's not working. And then, Mr. Chairman, to piggyback on top of Councilman Slief's, where's the courts, there's a hold up there. So did we reach out to the courts in regards to this? And how do we address this? We can do everything that we want to do, but then, if it takes in this instance 90 or 120 days to get into court because you had to do a 3-day notice and then a 30-day notice and then a hearing, I mean, are we just spinning our wheels, right? I think a lot more needs to be looked into this so that everybody, safety, license and assessment, the courts, so that everybody is on the same page with this moving forward, so that we don't run into snags within our own other departments like licenses and assessments or our other, the judicial branch.
Yes.
Are they ready? Are they prepared to this? I mean, it's becoming frustrating just passing feel-good pieces of legislation without everybody being on board for the enforcement of it.
Okay, and let me say before the administration responds, and I understand Councilman Casey's frustration. That's what prompted my discussions with the Safety Director Drummond, because I have long maintained that the law was not being enforced. And it was my frustration that I can continue to turn in the same addresses. And then I could count on one hand how many letters that I saw under the previous administration and under the previous director go out. That was my frustration. We worked on this again in 18 because of the problem. We asked repeatedly, as we continue to ask on all pieces, if there's things that are not working, to please let us know. The council's been very proactive in supporting administrative requests, but this hasn't worked. It hasn't worked, and we want it to work. So I'm going to be optimistic on this one. I'm hoping that the work that has been done up to this point, but Councilman Casey raises some very serious questions. If licenses and assessment and the commissioner there is not on board and not working with you very closely, then nothing's going to happen. And that was the problem, because they were not on board in the past. I can't tell you if those letters, the $100 fine was ever imposed. That's the problem. I don't know if it was ever imposed. So, Chief, you wanted to comment, or who? No? Okay. Councilman, you had any other comment?
yeah,
But you
I'm-
brought valid points.
I mean, and so are we really ready to pass this today, not knowing if the administration, safety, and everybody is on board with this? And I think really including, the judicial branch. What happens under Councilman Slife's,
Right.
scenario? Are they willing? Do we have to look at, other, other legislation that is going to prevent this from being effective? I just don't know at this point, Mr. Chairman, if we're ready for
Thank you.
for this. Thank
Through
you.
the chair, the
Yes.
councilman, this piece to me is very important for the property owners who we want to call. And I know there's other pieces that we definitely have to clean up, but if we want to hold everybody to the letter of what the ordinance is, property owners who are calling for issues that we've instructed them to call, our hands are going to be tied where they would get these letters, and we don't want that to happen because they're trying to fix the problem as well. So I think there's a small piece of that. I understand the frustration. I hear you loud and clear, and
Okay.
the assessments and license piece we have to clean up. I
Well,
agree.
Mr. Chairman, if
Yeah.
this has been in effect for 7 years now, right? So if it's taken 7 years just to figure that portion out, then we've got a lot more work to do on this
Okay.
legislation.
Have you folks been in contact with licenses and assessments?
Through the chair.
No.
No, we have not. But I will say, one, the courts really do not have any involvement with this ordinance because any appeal process goes through director, then the Board of Zoning Appeals.
Okay.
I understand with Councilman Slife's scenario, that is something that is tangentially affected by the nuisance law, but it's not something that is directly impacted by this. Why this was proposed is because when we came on and we were getting nuisance reports or complaints of properties and things, we were running into issues about we couldn't actually declare this a nuisance because of the way the ordinance was written. For example, there's a thirsty parrot issue. When you have patrons, right?
Explain to the viewing public where that was at.
That's near
Progressive field.
Progressive Field.
Okay.
There was issues with
Yes.
patrons visiting a bar that were blocking traffic.
Right.
The owner of the bar wasn't adequately controlling their own patrons, but we couldn't hold that person responsible or declare that a nuisance property because originally the only people that could be, as defined, could be doing a nuisance activity was an owner or an employee or an invitee necessarily, but how about people waiting to enter or customers waiting to enter or outside hanging around a certain area of because you're inviting a nuisance if you create an atmosphere, right, on your property where there just aren't any rules. This person's associated with was meant to address that problem that we ran into. Because now anybody who does a nuisance activity that is either entering, patronizing, waiting to enter a business, that business owner can now be responsible for that. So you have to hire more security guards. You have some responsibility to the public, to the rest of the neighborhood,
Right.
to control the people on your property. Also, we would get a lot of complaints about, I called hundreds of times about this nuisance property. There's all these calls here. And we see all the calls that were made to the property. But when you go into the section that discusses what happened on the call, it's, the people were gone, right?
Right.
And that's what you run into. Well, we have police all the time. Police don't have to witness everything, right? Otherwise, how are you going to prosecute a murder case? There's not police standing there when a murder is happening. Of course, that could be prosecuted. So then there's clarification here that now because what you need is probable cause that a nuisance activity occurred. This clarifies, even though it should go without saying, but it clarifies to give comfort and to give, so everybody's on the same page, that if you take a witness statement, you find that witness to be credible, that this activity occurred on the property, that could be used as probable cause that this activity occurred on that date. And that could be defended when it gets appealed to the Board of Zoning Appeals, because you have to show that each nuisance activity, that you have probable cause that each one of these activities occurred that you're citing. There was also a question about what action counts. It kind of goes with what I previously said. Before, it's only said there doesn't have to be a criminal conviction to show that a nuisance activity occurred. Well, then, depending on who you talk to, that could be interpreted, well, since that's specifically called out, then something else has to occur, like a citation or an arrest. So this calls out that, no, you don't need a citation or arrest. The advised or you spoke to someone and you documented it, that's enough. That counts as a nuisance activity. So I apologize that we do not have the numbers of how many, and I should have anticipated that, of how many nuisance letters we sent out in the past, how many fines have been sent out in the past, if somebody did not comply with the orders or the requirements of the nuisance property, like creating a plan. But I would say that this legislation was created because not just out of us sitting in an office just thinking of what could go wrong. It was actual events that we ran into and barriers we ran into, and we decided how can we fix those so we could take care of these properties in our neighborhoods.
Well, Mr. Chairman, to the title, what, assistant director.
Check.
2 points real quick. One, I would be careful, because are we making this too vague, right? Where you just got an angry neighbor who doesn't like their neighbor and now is just calling just for whatever reason, and this is becoming too broad, and are people going to be targeted if they're not liked in a neighborhood or something like that? So I would be overly cautious, just police don't have to, and we're going to rely on other people, because you could have 3 neighbors not like one guy, all 3 neighbors are calling all of a sudden just because people are calling, somebody's deemed a nuisance, right? So I'd caution that. And then my last point is to the Sarge, are you the only one in this department that deals with this throughout the whole city?
Councilman, through the chair, officially, yes.
Okay.
But I do incorporate commanders.
No, I get that. I mean,
Yes.
if we're broadening this, I believe that through the chair to the assistant director, that you're anticipating a lot more activity being deemed a nuisance, right? Because we're broadening it, and I just want to make sure that we're not going to run into a situation that we have in another department where we've got one individual and he's behind by 200 calls because he can't keep up with it because we've broadened it so much. I mean, there's so much more, I think, to think about
Okay.
on this one.
Thank
Thanks.
Thank you.
Mr. Chair.
Thank you, Councilman.
Through the chair, I'm sorry.
No, go ahead.
For your first question, that was actually brought up in our most recent meeting. I believe Sergeant Lanton brought this up about how do we prevent somebody that's being vindictive from abusing this. And I believe the discretion that is given to the director to actually send that nuisance letter, to evaluate, to talk to the property owner. This isn't just an automated thing that, oh, there's 3 things, we see it, there's a code here, okay, the letter goes out, this person's in trouble. No, there's a human component to it, which sometimes human components could be bad because there could be abuse, but this human component is evaluating it based on the merits of it.
Okay. Chief?
And to the chair, just a couple quick points on that. The commanders have a part in this, so that's a very important part, because we have the ability, to look at these, because there are instances where it is a neighbor dispute going back and forth. There absolutely has been that, and we would make sure to document that. And if it's an unsubstantiated complaint, to say just that. And just one other quick point of clarification when it comes to businesses. One of the things that we saw as a barrier for a long time were business owners saying, I can't control what happens outside, and I cannot control what happens in the parking lot. And that was, we constantly had that battle with business owners.
Yes.
They can only, their claim was they could only control what happened inside their establishment.
And that's incorrect.
And yes, and so this
Right.
is extremely helpful for us to hold them accountable for what happens in that parking lot, what happens in front of their store, because that was the biggest
Right.
defense that they used for law enforcement.
Because under state liquor law, they are responsible for their premise. So that's including the parking lot, that's including their sidewalk. That's, and I know because I've utilized that in many times in liquor hearings, that they were responsible. So again, I would urge I have Councilman Starr next, but I would certainly urge the administration, you folks, to sit down with licenses and assessments. And again, because this is what prompted my engagement with the director, my frustration, I mean, I think everyone's touched on it who's spoken so far, is that I felt the law wasn't being enforced. And I felt that, but yet no one was coming back to us and saying, well, this is what needs to be changed. This is what needs to be amended. We need to have dialogue with the housing corridor, And so I want to thank Director Drummond for initiating this whole movement here from the administrative side, because you got to go back to 2018. We passed this because council was constantly on the receiving end. We were going to neighborhood meetings and and hearing complaints one after another about that nuisance property or those nuisance neighbors. And what the chief alluded to, I had two where they were just constantly going at it, but then I brought in the Community Relations Board. And, we had the mediations, and thank God resolved it. But they were calling on one another left and right, and that's unfortunate, but that does happen at times. So, Councilman Starr, you're up next.
Thank you, Chair. I definitely want to try to be as brief. I thank my colleagues, Councilwoman House Jones, as well as Slife and Casey. All three made some valid points regarding this amendment of this ordinance. Obviously, it was established back in 2018, but I think the administration goal is to try to get it brought up into what we're actually dealing with in 2025 versus what we were dealing with in 2018. But I definitely do understand. My first question would be, just for the context of this ordinance that was brought to us, can the table through the chair just define what is nuisance? Because we keep saying nuisance, 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 and I want to make sure the viewers, the people at home understand what you mean when you say nuisance, because it can affect different parts of issues that we're dealing with in the city.
Okay, who would, from the administration, I know what my idea of a nuisance is, which prompted me to be the co-sponsor on this in 2018, but let the chief and whoever would like to respond. Chief.
I'll let the assistant director.
Okay, Director, you're up.
Chief, through the chair. Nuisances is defined by the acts that are in the ordinance. So you have in section 630.01, A1 through 18, all list what the nuisances are. Some examples as you go through it: animal violations, and it lists all the ordinances that go with that. Disorderly conduct, disorderly activity violations, drug abuse violations. Well, we added to that because previously it was only the codified ordinances, which the Cleveland Codified Ordinance, drug abuse violations, which are misdemeanors. So we threw in the Ohio Revised Code 2925. Violations include trafficking of felony level trafficking, things like that. Family offense violations, gambling, littering, liquor control violations, obscenity and sex offense violations that occur, offenses against other persons like assaults, property offenses like criminal damaging, theft violations, weapons, explosive violations, sound device violations, the massage establishment violations, explosive violations, open burning violations, and the two new ones that we added were safety and equipment violations, so like horn, sirens, warning devices, and mufflers cut out. So if people are messing around on the parking lot, an empty parking lot or an empty lot, we can cite that property as a nuisance because you have a responsibility to keep people that shouldn't be there off. And reckless operation, the new street racing, stunt driving.
Yes.
If that's takeovers, if that's occurring in a parking lot, let's even say like steel yards. Somebody's over there in a parking lot, they're not doing an adequate job of preventing people from acting up
Yeah.
over there, then that would be a nuisance activity. So all of the nuisance activities are defined within the
Okay.
ordinance.
Councilman?
Yep, and to that point, obviously, I had put up some research to make sure I get clarity as far as nuisance too, because one of the things that we deal with in the city is obviously property owners, whether it's LLC, whether it's private, different board ups that need to do, houses that need to come down that haven't been torn down, or different opportunities definitely in the neighborhood. So when I look at nuisance, I think it could be defined as can be a public or private, and it can include a wide range of activities similar to what Councilman Casey was bringing up, where it could be loud or disruptive noises. It could be offensive orders. There can be unsafe or unsanitary conditions, unauthorized use of another person's property, blocking access to public roads or walkways, creating hazardous conditions that poses a risk for public safety or health, interfering with a person's quiet enjoyment of their property. So when we say we're going to make this amendment, how it's so written and it's so broad, how can we dive deep or hone in on the top issues that we are dealing with so you can have the legal authority to go after these different things? So I hear what public safety is doing. I wish this would have been a conversation that we had building and housing at the table, as well as the courts at the table, because it can't be we passed a legislation and gave authority, but then everyone is not in agreement. So even if we make it into law, how do we have things in place to make sure we do not have to come back to re-amend some different things when we don't have everything at the front of our table? Like, just to be honest, like me and Residents First Initiative Ordinance, that is one of the things that we say is working, but it's not. And what I mean by that is residents are getting letters in the mail saying that they didn't register their property, but at the same time, when they call down to the department, they can't even get assistance on how to do it. So if I'm a homeowner who bought a house and bought a couple different properties just to try to create some additional revenue and tried to get by back 20, 30 years ago, and now they are seniors, and once it was paper-driven, and now the administration has came up with this Resident First initiative where I'm not technology-driven. So therefore, when I call and try to get assistance, I don't got the support to get the assistance. They're being told to get their grandchild or somebody else to help them, which happens if they don't have that. The staff don't have enough people in the office to work with them and giving them the technical IT assistance because everything is online. And guess what? They missed the deadline. Now they get something in the mail, and now they're being penalized because of they couldn't register. So now their property is deemed a nuisance property. But if we had everything in place to help the individual, it seemed as if we penalizing people for having properties, but not going after the ones who are really abusing the law that we have. So I definitely think we need to really possibly hold this Chairman
Yes.
Palenzi, because we do not have everything in place to make a good vote on this, similar to some of the things that Councilman Casey brought up, is to make sure we have everything in line, because mailing people out first-class letters that we pay more dollars for to say that your property is not registered and you're in trouble, that is not it. We don't even have enough inspectors to go out. And then we just hear from Sergeant that he's a one-man department for a city with a population of 374,000 residents. And I can't, well, through the chair, I would definitely like to ask, do we even have a number to tell you how many properties or owners do we have as amount of properties that we have in the city? Do we have that type of data to say, like, this is how many properties we have, this is what we're looking at, things like that? I think we need to really hone in and really make sure we got everything in place before we vote on something such as these type of amendments, through the chair.
Thank you, Councilman. I appreciate it. Anyone want to respond from the administration?
Through the chair, the councilman. I certainly understand those concerns, Councilman. And let's give you a little peek behind the curtain. That the great thing about legislation, right, versus charter amendments or constitutions, is that you could see how they work on the ground, and then you could make changes if something unanticipated happened. You know, Colin Powell has this 60-40 rule that if you have 40% of the information, it's probably not enough to make a good decision. If you're around 60, 70% of the information, getting any more, it's going to cause paralysis, right? I could tell you what we have been doing in anticipation of this legislation and reviewing the policies. There is, some would call it a cheat sheet, some would call it a procedure, but of how things, because you have the legislation, and then we could call it, at least in the state, you have your ORC and you have your OAC, Administrative Code. You have your regulations. In the feds, you have your CFRs. It kind of dictates how the legislation is actually implemented. In the city, it's more of like internal policies of how you actually implement the legislation. I'd say how we've been doing nuisance abatement in the past is these reports are run each Monday in whatever program it was, by district, date and time, and it shows, okay, which ones have 3 or more calls in the allotted time period? Which addresses have the 3 or more calls? Then you go and you check the weekly nuisance report. Okay, we have a whole list of properties that have received at least 3 or more calls. You check, hey, is that property already on that list? It is? Okay. Is that property not on that nuisance list? Okay, well, we gotta do what we need to do to send out the letter, verify if those nuisances occur. We haven't run into the issue currently where it's a staffing issue. Is it possible that by broadening, making it easier to be identified as a nuisance in that, which I think was the intent of council, was that if somebody heard something bothered, they called the police, but the people are gone. You still want that counted as a nuisance,
Right.
as long as there's probable cause.
Right.
And that also goes to the, if it was a vindictive caller, I mean, you really don't have probable cause that something occurred if you determined by speaking with that person who reported that, oh, this person just has an issue with that neighbor. Then your probable cause is gone because that person's not credible. So really, getting statements that are credible, probable cause that nuisance activity occurred. We have a system already in place. We'll have to make some tweaks, and we're anticipating we're going to have to make some tweaks to how we do it. And then there's, of course, going to have because all of that goes on our end. The part that is not on our end is actually sending out, or the fines that go through division assessment licenses. That's going to have to be an internal process. Is it better? I guess there's different philosophies. People could disagree of whether do you get the actual rules of the road put in place through this having the ordinance passed, and then you go and say, okay, how are we going to make this work? Because unless this is passed under emergency, right? Typically ordinances do not go into effect, what is it, 60 days, 30 days? 30 days
Yeah.
if it's not under emergency, which
Right.
gives time to ramp up. So you don't have to pass it under emergency. Give time to speak with assessment license to create a process in order to make sure everybody's on the same page and streamlined. But if you don't have the rules on the road and you're anticipating, oh, there could be amendment here at the table that's going to change how we do talk with division and assessment license, it's good to, I guess my belief, and you could disagree with it, is up to council to do your will and what you think is best, that we have the rules of the road through the ordinance. Once we know what we're working with, then we could have the conversations to change or alter our internal policies and our policies and our procedure with division assessment and licenses to get it all on the same page in accordance with the legislation.
Right. Okay. Councilman?
Yes, through the chair, I like that explanation, but at the same time, I don't think it gets to the root causes or solution to the problem. Like, I always believe in the reason why you have HR is because HR is not just to fire and hire you. Is to get people in order to do their job, get them in line. Maybe they need some training. Maybe they need some skills. It seems as if we're looking to penalize everybody. And when you start talking about nuisance and you start talking about all these different categories that fall under this ordinance, one thing that comes to mind in me is what do you do with nuisance call regarding arguing, fighting that may be an act of domestic violence? Now it could be, well, I'm calling because you know, he ain't come home tonight. Now it became a big issue. Now the neighbor across the walk heard them arguing. Now they keep calling 3 or 3 times. Then what happens? You know, those type of things. And that's why I'm saying from a collective unit, I think we need to have really a committee hearing where we have the housing court here, where we have building and housing here, and the safety to say, what do you have internal policies in place in your department, this department, and all departments, and what do we recommend together as a collective as far as amending? And through the chair, my direct question would be, have the safety department worked with all 3 on this actual topic and got a response in writing back from those departments regarding this changes to this ordinance 228-225?
Director?
Through the chair, to the councilman, I think the first thing you brought up, this is one piece of legislation or one ordinance is not going to solve all the ills in the city of Cleveland.
Right.
This is one tool in the toolbox that we're trying to, we have a broken hammer. This is a hammer. It's broken, we're trying to fix it. In terms of types of calls that are not included, there is a list of calls that are not included, including domestic violence. We don't use that as, we don't count that as towards a nuisance. Overdoses, we don't. Mental health calls, we don't. Welfare checks, dead on arrivals, natural, we don't. Special attentions. So the good thing about, this isn't brand new legislation. This is originally amendment to one that exists. So what we did was we test drove that. We saw how it worked. We heard that there were issues from council. We found that when we were trying to implement it, even as recently as I've only been in public safety since August, and from my experience since August, that it wasn't working in these ways. And these are to address those specific issues. Can there be a whole comprehensive? You could attack this at different levels. We already have the nuisance ordinance on the books. We're trying to improve it so it's more workable, more enforceable. Those conversations, and I believe the chief could speak to this, about her officers do a great job on these calls, that if it's is a neighbor dispute or someone's in distress or we always try to work things out before it gets to the point of we have to start doing some sort of intervention. This isn't, again, it's not robotic. There is a human element of problem solving and some sort of community organization in this part.
Okay. Thank you. Thank you. Councilman Sarr, any final comment?
No,
Okay,
I just,
thank
my final thoughts is I would love to make sure all departments and all parties
Thank you.
are all in agreement with this amendment to ensure that we are addressing the actual issues that residents have mentioned to our offices from council standpoint to ensure that we're doing everything we can to address these nuisance
Okay.
issues.
Thank you.
Thank you, Chair.
Councilwoman Stephanie House-Jones.
Thank you. Through the chair to the team here, there have been varying different conversations here. So I guess I just have a question of, currently, through the chair, the assistant director was talking about the administrative procedures that currently are set up in a public safety. Do you all have some level of written procedures of how you are dealing with nuisances that are part of your procedures that have been shared? I'm assuming it has Chair Polensek and Council President Griffin listed on this legislation, so I'm assuming your teams have been working together on this piece of legislation? And where the process has been outlined?
Who would care to comment?
Yes, I believe this was done at request. We heard feedback from, with the meetings that Director Drummond does have with
With myself.
Safety Chair, that this came down like, hey, we need to address this nuisance roam. So that's where that originated from, based upon the comments and issues that Mr. Polensek, Councilman Polensek has shared with us. We do have written procedures that are, Sergeant Lanton could probably speak more to that, but we do have nuisance of how declaration of, that's what I'm looking at right now.
Right. So
Right.
the reason why I asked through the chair to the assistant director, because you talked about how while we have our formal charter code ordinances, there are then administrative procedures that are written down. And so, have you shared that with anybody on public safety or anything like that, so that maybe that can clarify or even build a level of confidence that public safety actually has written procedures as it related to nuisance? I'm offering a suggestion for your legislation. If you haven't done that, that's me offering a suggestion so that people can actually have a level of confidence that the things that we are talking about have been brought up have been brought up, have been looked at, and there is a written formal process. Through the chair to the assistant director, is a part of that in your administrative procedures identifying how you collect data as it relates to nuisance and how you report out on it?
Director?
I see somebody, maybe the person who's shaking his head. Your lieutenant might want to
Sergeant?
comment
I'll
on it.
let Landon answer. He seems to know.
Councilwoman, through the chair, we have a specific process.
Sarge, pull the mic close to your cup.
I'm
Thank
sorry.
you.
We do have a specific process. I have shared the process with several council people who have come to me about nuisance property, asking me, well, what is our process? And I have shared that with a number of council people, how we go about identifying nuisance properties. And it goes through number of calls, types of calls that we can use, types of calls that we can't. We talk about utilizing our community engagement officers. We do have a process in place. So I can't say that I've shared it with everyone, but any council person who has requested that information, we have shared that.
So, okay, again, maybe I'll clarify my question. Through the chair to the team here, do you all have a written process of how you're collecting data?
Who can answer that?
I'll
Okay,
answer. So
Chief.
through the chair to Councilwoman House Jones, it's pulled from our CAD system. So it's for the calls for service, if that addresses your question.
It doesn't. So probably the answer is no. So again, and the reason why I'm asking this is because based on my experience here, we need to have a very clear understanding of, while we are pulling data, how do you even know what data to pull if you do not have a defined a divine outline of these are the inputs that we actually need to then yield a report to say something, explicitly laying the foundational framework of the story that we are trying to tell. And I'm really on this, and I'm going to be on this because it is a maze of information, and I do not think that for purposes that I've been able to try to gather to be able to tell a complete story when it comes within the realm of public safety, I've just not been clearly informed on how we are actually collecting data. And so that's why I'm asking this question. We don't have a process. So let me ask, because that's what I'm getting to.
Well,
And
see,
you were
that-
about to say something.
okay.
You're saying it's not true, but not as accurate, but chair.
Okay.
Please, to the chair.
Double pressing.
Just pull it up close so people can hear.
Thank you. Through the chair to the councilwoman, just as a clarifying question, do you mean in getting the data necessary to declare a property a nuisance, or are you talking about in the data of kind of checking our performance or evaluation?
The first step is declaring a nuisance.
Okay.
Okay.
The way that is, because if I understand the question correctly, and I'm sorry if I don't, which wouldn't be unusual. with reports that are run, the things that are pulled are the incident number, the call date and time, the location, which of course that's the most important, the incident type, and then the disposition. So those are the pieces of data that are pulled. Now,
That's a good,
example,
through the chair,
Yeah.
and those are the things that are written down in your administrative rule?
so the administrative rule is a
Or
little
your,
less formal.
or your ordinance, that's what I'm saying. I'm trying to figure out the formal process that you all have established to pull this level of data. What is your guiding document? Because if you have a new person that's on board, what do they reference to know this is the information, the information that we need to collect from the incident itself, and then you're running a report. How do people know that's what they need to do?
Okay.
Okay. Whoever wants a comment?
Do you know, Sergeant?
You-
I think what you pointed out is a very good point, and I understand.
so for
is that,
example-
like for whoever's going to come on next, you're recommending that we have something written out that says, when you want to run a report based on this, the report should include X, Y, and Z. It's pulled this way. My understanding is that we likely have already a form report. It's a form report that you just click on it, and it's already set up that it pulls. So our procedure says to run that report that's already built to pull the data that is necessary.
Through the chair to the team here, so even in the form report, right, is the form report that you have said that is already established, is it yielding the results based on this conversation? This is what I'm asking. Even in your form report, does it make a determination? Because we're saying that what we are proposing will help in the incidents where a property owner is calling themselves and it is making a determination that no, this is not residents calling about the property. It's the property owner themselves that are reporting. Is that delineation is in your form nuisance report?
Go ahead.
So I'll speak on that real quick.
Yes.
So through the chair to Councilwoman House Jones, that's the human factor of it. So the report is generated based on the violations and the calls for service. So when the CAD system that is identified of what type of call for service it is, it identifies that, and that information is pulled into the report that they're generating. As far as who the caller is, that's the human portion. So that is the portion where the determination about the nuisance property, that's the conversations that are held at the commander level or the director level. Then they're working with that person to identify, I'm the caller, I'm the one who's reporting these problems, or they work with the person, the individual involved from there. So part of it is computer generated based on the calls for service and the call types, and part of that is a human portion.
Yeah, through the chair of the council, if I can explain. The computer-aided dispatch, which is CAD, I want to make sure the viewers understand what CAD means. It's the calls for service that the 911 call takers put in. If we were just blanketing, sending out nuisance, we could actually run a report where it would kick the address in and they would automatically get a letter. And I think the chief's alluding to the human portion where we have to look at those calls for service. What were they? Who reported them? It's more specific than we could do a report, automatically generate a letter for anybody with over 3 calls in a time period, and it would kick an automated letter out. But we don't want to do that because we have to look at why the person called, what the circumstances were, and that's where Sergeant Lanton reviews it and does his process that he has written down. So there is a built-in data report that does get pulled, and it's a canned report that we have that gets run every Monday. We can put in there what it is so that when we change databases or other information that somebody, if they're no longer here, somebody can fill in that role very easily, and I don't disagree with that. We should have what we're pulling, but there is that human element. The chief stresses, AD stressed, and as the sergeant, we have to look at these calls for service and not just automatically kick a report or a letter out to them.
Well, see, this is what I'm saying through the chair to the team. Beyond that, sometimes there may need to be an adjustment in actually the report that you're establishing, right? If we are noticing that, I don't know if that is a trend of how many property owners are self-reporting. when you think about the amount of information, the time and the capacity that people have to take in these informations, data should be used to inform decision making, inform policy making, because we are a lot of times faced with many very large tasks to do a lot of things at once. And so at this point, I would just, because we are going on and on, I will offer a couple of suggestions through the chair to the team as it relates to this conversation. Whoever within the department was crafting this legislation, outside of actually having a formal committee, I really would encourage you all to have some interested party meetings, specifically someone from the legislative branch, building the house and whatever, to go through all these things to ensure on the administrative side, the information that is wanting to be gathered can be clearly gathered. Two, I will, at some point, I'm trying to figure out how we can have a requirement to share the data in a way, because I'm like, even with this open data dashboard, nuisance reports can be pulled from here.
Whoever can comment.
The open data portal, yeah, you can pull calls.
Yeah.
Through the chair of the councilwoman, yes, the calls for
Yes, you can.
service are on the open data portal. It doesn't give the entire address. If you notice, some of the last few numbers are X'd out. So it kind of gives you general where they're at, calls for service in the open data portal, but it's not going to have the exact, all the digits of that address in the calls for service.
And that's for protection for the.
Yes,
Yes.
correct,
And-
that's
and
correct.
Through the chair, the reports that are generated are not the investigation. It triggers investigation. So it triggers someone from public safety, in this case Sergeant Lanton, to look into those actual calls and be like, okay, do these really do qualify? You know, because it could be a false alarm type, you know, with anything that is
Yeah.
automated, sometimes you get some false alerts in there. There's the human element. This triggers, oh, I need to look at that. So Sergeant Langton looks at it, sees if there's probable cause for that the nuisance activity occurred, and we move through the process from there.
Council lady?
Okay. Good.
Okay, thank you. Councilwoman Gray.
Okay, thank you, Chair. I'm not going to be redundant with the same questions that my colleagues ask because I'm on the same page as them. Just a little confusing for me for the team to come to the table without any data to back up what you want to be amended on this ordinance. So, to say the least, I have the same concerns in this ordinance as my colleagues. You have in here, I just want to specify certain things that you have in this ordinance, as in my doggone computer froze. Say one incident in this ordinance that you have here stating that like. One of the nuisance states that you have burning incidents, when someone out there burning wood or any wood in their yard. I think it's in there. My computer just froze. Okay, that's a nuisance, correct? Somebody called on that. But when they call on that, the fire department comes out to deal with that. Chair to the team, when the fire department come out and take care of someone burning wood or whatever in their, on their property, and that's called in to the fire department, and that's a nuisance call. So, so where does that call generate to once they put it in the system? Who gets that nuisance call? Chair to the team.
Through the chair and through the councilwoman, the call goes through central dispatch and is recorded in the CAD system. So it's a call for the open burning, which all the nuisance definitions, we didn't change any of those except for adding felony level drug offenses and the noise from vehicles and the street takeovers. So it would get pulled into this type of report if there were 3 or more calls within a period of time, within 6 months. Then it would end up on a report, and at that point, Sergeant Lanton would look further into it to deem if there was probable cause that those nuisance activities did occur on those dates. In that sense, if a fire department went out and you see a report that they put out the fire, then yeah, there's probable cause that that occurred, so that counts as a nuisance activity. And I would say in terms of past data of how this has worked in the past, I mean, if the data showed that we really didn't issue any letters or very few letters, would that data show that people actually there were no nuisances occurring? Or does that data show that the way nuisances are defined or the way that we actually are able to enforce nuisances is flawed? So I don't know how helpful like that piece of data would be. If it showed that we were sending tons of letters, which is clearly not the case because we wouldn't have to keep running into problems where we can't send a letter. We get notified, that's what we run into, where we know that something wrong is happening in the community, that neighbors are complaining about this property, and we can't do anything about it because the ordinances as currently written is too narrow. So that's why this came in to provide those fixes.
Okay.
Okay.
Council Lady?
Okay, and I like that answer. However, saying that, I think that more data should have been brought to the table for a more explanation on why you want to amend this ordinance, which is good because it's past tense and we in today and things are different today. So Sergeant Lanton, would that have, Chair to Sergeant Lanton, would that been data that you should have brought to the table since you are leading on these particular nuisance incidents, going around Cuyahoga County? Would you have brought that specific data to the table for us to see of all the current nuisances that's going on for us to consider to amend this ordinance? Chair to Sergeant.
Sergeant?
Councilwoman, through the chair, the issue with the current data, it shows that we're not taking action.
Well, yeah, that's part of our problem.
It shows that we're not taking action because the way that the ordinance is set up, it prevents us from taking action. So that's why we wanted to make these changes. The data, we can share letters that we sent out, but we can share how many calls or how many requests we received where no action was taken because the way the ordinance was written, it prevented us from taking any action. So I'm not sure how, in this framework, how data would help, because we're telling you it's not working. And the complaints that you're getting is telling you it's not working.
Yeah, well, that's what prompted my...
That was how all this came about. It wasn't so much what we were not doing, it was we're telling you we can't do anything because how the ordinance is written. And so that's why I'm a little confused about the data aspect of it.
Okay, let me try to get some clarification here. Do you keep data by ward?
Yes.
You keep data by ward. So part of, to my colleague, Councilwoman Gray, part of my discussion with Drummond was just that I was co-sponsor this piece, but no one, and I, like all my colleagues, kept turning in addresses, locations, but I felt very passionately and strongly that the law was not being enforced. But no one was coming back to us from the previous administrations to say, well, this is what's wrong with it. This is what needs to be changed, da, 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 da. So council people, our citizens continue to turn in complaints, but we are not getting the results. We're not getting the end product. So again, that's why I said I want to thank Council, the chair, I want to thank the Safety Director, Mr. Drummond, for taking up my concerns as been put to me by my colleague and say, we're going to figure out what's wrong here. So whatever data you do have by ward, put that together for us, okay? Based on not only Councilwoman Gray's request, but all of us. But on the other side of this equation, we know we have to do something. We have to, because summer is coming upon us, and we continue to have these nuisance problems in our neighborhoods, complaints. I know, I get them, like I said, I'm dealing with this land bank lot last week. So whatever data you folks can put together, you need to assemble that as soon as possible. Whatever data License and Assessments has, which again, that's going to be very interesting to see what they've done, they need to put that together because they have to be a partner with you on this whole process. So besides
I have a
Councilman,
couple
I'm
more
going to let you
questions.
finish
Yeah,
because then
yes,
we're going to try to wrap this up.
All right, thank you. But I want to chair to what you just stated with license and assessment. I did have a conversation with them last year, and I asked them about how do they assess their data due to food trucks and hot dog carts that illegally be in parking lots at the rec centers, because that is a nuisance to due to residents that be at the parks. And then you have so many food trucks and hot dog carts in the parking lot in rec centers, and that's a violation. And I'm not the police, and I don't police. I'm not the policing anything, but to see that has become massive. So when I talk with License and Assessment about food trucks and hot dog carts in the parking lot, because it interferes with the activity of other cars parking in the parking lot, and then all the activity that goes on. And I don't be policing anything, but I hear from just patrons that be in the residents be out in the parks. That becomes a nuisance to them because there's nowhere to park. They're constantly pushing them to buy their food, and the food trucks and the hot dog carts should not be in the parking lot of rec centers. And there is a notice of violation saying that no food trucks or hot dog carts are permitted in the parking lot. So when I brought that to License Assessment attention last year, they had said that due at one time, they did govern that. However, it was like canceled or eliminated out, and they wanted to they wanted that something to the fact to be amended so they can go out, because so they can come back out to cite food trucks and hot dog carts being in parking lots. But somewhere along the line it was. I don't know, because I wasn't here years ago, but I just brought it up now. But they said that they wanted that to be amended so they could come back out and start.
Food carts have to be signed off by the council person. Mobile food trucks have to be signed off, have to be agreed to by the council person. And on city property, I don't even know if that's, to me, that's only being redundant. I would assume, being on city property, that that's unlawful. You can't come on without being allowed, and somebody has to allow that. So the question, I would say, again, this is another component here. Maybe
That's another nuisance.
Put that in. Look at this as some type of addition to this. But that's been my understanding.
Yes.
Historically, council people have to sign off on the food trucks, and if you don't sign off, it's illegal. Even if they set up in the street, it's illegal.
Right,
because of just this problem of having conflict or setting up in front of a local business that is already there paying rent, supporting the community, and setting up in front of them. That was the reason for the sign-off requested by city council members. Council, any additional?
Yes, so yes,
Yeah.
I'm just saying, I just want to put that out there
okay.
as well, that has become a nuisance
Okay.
on the Rex parking lots, but it states that food trucks and hot dog carts are not allowed in a recreational parking lot. So just say the least,
Okay.
as my colleague Starr stated, that there's other issues that's going on that's not in this ordinance to legislate for us to
Okay.
even vote on. So
Okay.
we have a various of different things that's not being looked at. And one more thing, Chair,
Yes.
to the committee, this, and Chief Chobb, I just want to get this out because you might want to say something about this. I have, also have various areas, and I think other councils do, and I have both addresses on this card, that I had called on public safety of actual homeowners doing auto mechanic work on a residential street. And these two locations have been called in several times from residents that live on the street. And I know for a fact, public safety has come out, ticket those two areas, ticket them and tow their cars. I have actually ran into the officer that's in my ward that does a great job that I pull up on when she's out there in her car, and she tells them to move your cars, get the cars off the street, because she have already stated to me that that she has a running record, and the next incident, whereas that homeowner, that homeowner will be cited and be brought
Okay.
into court. So I'm saying that these are different nuisance calls that's that has been addressed, but it's not in the amendment per se.
Okay.
So just to say the least, I think I agree with my colleagues that we need to look at this in a different way before we move
Okay.
forward. Thank you, Chair.
So
Can I
that's-
just
that's-
comment really quick to clear that
Go
up?
ahead.
So through the chair to Councilman Gray, those are crime violations. The hot dog cart is a vendor enforcement that we can actually enforce. We don't need the nuisance crime for. The parking, working in the driveways, again, those are immediate things that don't need to necessarily be in the ordinance here. Those can be immediately addressed through the, either through the administration, through the city, or through police.
Okay, so just on that point of the vehicle, we know working on motor vehicles in your yard is in violation of the housing code. We know that. In the street, is it a ticketable offense?
Yes.
Okay, it is. It's just an enforcement issue then, correct? Okay. So to people who are watching this, if there's someone in the street working on cars, then I would urge you to call the police. And so it is a ticketable offense. I want to do some clarity here so we can move on. You heard the concerns of the body, the points that have been made. We're looking for data. So I'm going to hold this for a week. But I need you to get licenses and assessments engaged in this. And also, I'm going to urge you to be in contact with Director Sally Martin, and then also the housing court, because we have to make sure we're all in this thing together. I'm like most around here, at least I am. We can hold stuff forever, and we can uni things to death, as I've seen in my time here. But at the end of the day, we've got to get, we know this isn't working. I know it isn't working. I can tell you as the co-sponsor of it, it wasn't being enforced. Even those provisions that were in there that were clearly identifiable, that's what prompted my discussions with Director Drummond. So we're going to hold it a week, put whatever data you have assembled. It'd be very interesting to see what license and assessments is done. I also want to know if there was ever any sent over to the county for the assessment. I wouldn't bet my life on that, but it'd be interesting to see if there was, because ultimately that was the hammer. You don't want to respond. You don't want to respond. You don't pay the $100. Boom, it goes to the county to be put on your taxes. But we don't know. None of us know if that was ever implemented by anyone here at City Hall. Again, I'm going to say, council does not administer. We work on legislation. We pass legislation. We pass this with the intent that it would have an impact. I think in some cases it did, but a lot of others it didn't. So we're going to hold it a week. You've heard what our requests are. And so I want to get this moved before summer. because that's why Assistant Director Schaffner mentioned to me that you guys needed this and wanted this before summer. We're on the same page there. We want to be able to give Sergeant Lanton, we want him to have the tools that he needs to enforce this law. And so are there any other requests of the committee to the administration? But we're going to hear this in a week. We want to get this thing done. Any other requests of the administration, of the safety directors, the two that are here, assistant safety directors, sergeant, and the chief? Any other requests? Any other comments? Okay, we're going to hold it for a week. We're moving on. Okay, don't go away, anybody, because we got a couple things here. Okay, don't go nowhere. But anyway, summer safety plan. Listen up. I've been talking to the director about the summer safety plan, which has great concern to all of us in City Council and our citizens of what the game plan is for warm weather. I know the administration has been diligently working on a summer safety plan, according to the director. It is not in place totally, but I wanted the chief to bring us up to speed a little bit as to where we are in this whole process. Chief Todd.
Yes, sir. So to the chair, the Division of Police is looking to implement a similar summer safety plan as last year,
Yes.
where we have our microgrid enforcement areas that we define as hotspots to address violent crime in those areas. A big part of our enforcement efforts as well would be traffic initiatives. We are partnering with the Ohio State Highway Patrol
Good.
for the traffic initiatives throughout the neighborhood. For the violent crime initiatives, it's not only the Division of Police, but our federal, state, and local partners that we work with to address violent crime throughout the
Okay.
city. This is still a work in progress. There's still, under Mayor Bibb, we have an all-of-government approach to look at, the nuisance problems in the area, nuisance properties, spray painting, trash, abandoned homes.
Right.
That is all going to be a part of our initiative moving
Good.
forward with the summer.
Okay, so at some point, you'll have it solidified. You'll come to the table and you'll explain it in detail to us.
Yes, sir.
You'll let us know when that's going to take. Staffing and hiring,
Yes,
where
sir.
are we at this point?
So our current staffing, we are at 1201.
1201.
Of that, 74 of those are recruits, so that leaves us with 1127 sworn members.
11, what is it?
1127.
27. Of the recruits, how many was that again?
74.
74. When will the next class graduate?
April 25th.
April 25th.
Or do we move it to the 24th? We moved it to the 24th.
And
I'm
what is
sorry.
it?
We moved it to April 24th. I'm
April
sorry, the Thursday.
24th. And as I've indicated to the director, historically in the past, the chamber was always available for graduation.
We appreciate
And
that,
for
sir.
some reason, we got off that track. But again, the cameras are already set up, the lighting is there, the sound system is there. So please, all you'd have to do is coordinate with the clerk of council, because most of the people who attend those events park at City Hall anyway, in Willard Park Garage.
So the ceremony slated for April 24th will be at South High.
That one will
That's
be
going
at
to be at the
South High.
Public Safety Training Center.
Okay.
And that's going to be 28 recruits that graduate from that class.
28 recruits. Okay.
And then we have another class that is slated to graduate on August 1st, and that is currently at 45 recruits.
August 1st. 45 recruits. Good.
We'll have another academy class starting on April 28th.
Yeah.
The-
April 28th.
Yes, sir. And they are tentatively scheduled to graduate. I'm sorry, we don't have that date yet because I didn't
Okay.
start.
If you could send me that in an email.
Yep.
And then I'll disseminate that to all my colleagues. It'd be very helpful.
And I brought these as well. So
Okay.
we have another hiring event coming up.
Okay,
this is
tell
the-
everybody that, because
So we have a hiring event coming up May 2nd,
let
3rd,
me have
and
one
4th.
so I can see one of your flyers.
Absolutely.
Thank you. Want to pass it out to
Yep.
my colleagues?
If you want to take, I have
Yeah,
enough for
okay,
everyone.
good.
If you
Good.
have, you want to share those throughout your community meetings. The hiring event will be a 3-day hiring event as well. We currently have 285 candidates registered for the training event.
Good.
And we are still, it is walk-in, but you can also pre-register, which will give you an actual time slot for attendance. There's a QR code that's on the flyer, which will take you to the site and give you more information
Okay.
related to the hiring event. As you know, these have been very successful.
Yes.
With this class, the hiring event, we anticipate the class starting August 11th.
Okay, so you'll get me that data, that information.
Yes, sir.
And again, I strongly support these new types of events, and I've said publicly, maybe some of the other departments and divisions should be doing likewise, because we keep hearing we have vacancies and we can't find employees, but you folks have demonstrated that there are people who are willing to apply, but the problem historically has been it takes too long to get hired in the city.
Absolutely.
And we got to figure out, and you guys are working on how to enhance that process.
And if I can just
Yeah, go
really
ahead.
quickly state, I have to, really recognize our recruitment unit. What they do with the candidates is they follow them through the process. They
Okay.
keep them updated to keep them involved in the process and to make
Okay.
sure their interest stays peaked.
Thank you. As a result of the negotiations between the Cleveland Police Patrolmen's Association and the administration, and obviously we had the legislation up before us on Monday, so we saw the 3, 3, and 3. With the 3%, what would the starting salary be for a patrol officer?
Give me 1 second. I brought all the
Okay.
language changes. I
Okay.
did not bring the salary
Okay,
rates.
okay, well then I'll let, so I'll let whoever wants to touch on that a moment. But in the negotiations, in the contract, what we know that, again, the 3, 3, and 3 were there. Was there, and you and I spoke on the phone about this, was there anything out of the ordinary, any changes to general police orders, any as it pertains to discipline? Is there anything that council members should have been aware of or need to be aware of that we didn't, looking at the provisions that we might have overlooked?
To the chair, so the contract, the changes in the contract or amendments were basically related to administrative operations.
Okay.
They were related to internal investigations. They were related to vacations, the regular HR
Right.
issues with insurance, longevity, the officer's uniform allowance, the furlough changes.
yeah.
And everything related to officer salary and pay
Okay,
package.
so, because that's what you explained, it was all administrative. So, because as I indicated, the CPC had contacted me, and they indicated that somehow, in their infinite wisdom, that they felt that they needed to review this prior to council ratification. And historically, as we all know, collective bargaining is governed by the state of Ohio.
I have it.
That's who governs collective bargaining. Once the administration negotiates a collective bargaining agreement, and the membership, in this case, the Cleveland Police Patrolmen's Association, ratifies it, the council has never objected to that, has never blocked that ratification with a vote within the body, and so I made that clear to the folks who contacted me from the Cleveland Police, from the CPC, the Community Police Commission, that whatever action they take, that's their business. But from our perspective, once the rank and file, you happen to recall what the vote was on that? The
final vote for the
but it was overwhelming.
it was majority, yes.
The
sir.
majority of Cleveland
Yep.
police officers voted in support of the contract, which was negotiated not by city council, but by the administration. And at that point, we have never blocked or delayed the implementation of a collective bargaining unit. To my knowledge, we've never done that, and we're not about to do that, okay? We're here to work with the police, and I'm going to make it very clear, I supported the 3, 3, and 3. We have to bring our salary levels up to a point where we are competitive with our suburban neighbors. I heard that repeatedly, and we're doing that. And I believe, and please correct me if I'm wrong, we might be, in some cases now, we are exceeding the pay bands of suburban departments.
I have those numbers when you're ready, sir.
Yeah.
So, to the chair, for top pay, which is an officer who has over 5 years,
Yes.
for the first contract, the top pay is $86,918.83. In the second year of the contract, it's $89,526.39. And in the third year of the contract, it's $92,212.18.
Yeah. Now, we might not be able to compete against some of the more exclusive exclusive communities across the state of Ohio, but I can tell you, based on that pay band that you just outlined to us, that we're very competitive now.
Yes, sir.
And that was lacking, and it was tremendously lacking. And that's why the council advocated for the hiring bonus. That's why we advocated for a higher increase in pay. Because I'm hoping that anyone watching this now, we just talked about the hiring event on May 2nd, 3rd, and the 4th, right here at City Hall, that you come in the gate as a new police officer, you're going to make $86,918.
It's after 5 years.
After 5 years.
Yeah, after 5 years.
5 years.
Yes.
$86,918.83.
That's correct.
And so that's something that we need to promote. We need to
Absolutely.
promote that, and I've been promoting it in my own community. Okay, just a couple other questions here, then we're going to be, because other council members, we have to go on other meetings. Okay, so staffing and hiring, we've got those numbers. You're going to get them to me. Director Drummond indicated at some point you're coming back with me with a couple dates as to when the effort will be taken to remove the other identified cars in the river.
Yes, sir. So, to the chair, we are currently have a plan in place. We're just waiting weather related.
Yes.
We're looking at the end of April to the beginning of May.
Thank you. Thank you. We want any identifiable car in the river taken out, and where our vehicles are being deposited. As I've said to the director, I need those property owners in partnership with Building House. They need to be notified. They have to put up bollards or some type of barrier, because they're putting a burden upon the Cleveland Division of Police, but also we know that these vehicles could be used in the commission of a crime, and so we want to make sure they're not being deposited in the river.
And
So-
to the chair,
yeah.
our Homeland.
Listen up.
Our Homeland Services Commander is working with the property owners
Good.
for that specifically.
Thank you, Chief. I appreciate that. The last thing I wanted to address, and then open it up for general questions, and we have listen up, we have two speakers that will be allowed at the 3 minutes that we normally allow. We know from reports with regard to the federal, well, let me just back up a moment. The federal monitor has still not approved the use of the drones, correct?
So to the chair, that is back, and the monitors have added their edits. The policy is back with the CPC currently.
Is sitting in the CPC. Do we have any indication when they're going to do whatever they do?
So to the chair, I know that their committee is just seated, and
Yes.
we are scheduling dates for our next communication with them on that policy.
Please keep the council apprised. The council want the drones up.
Understood.
We want the drones up to protect our citizens. And those people, like this crackpot that came down here on Monday about the drones, that we have cameras all over the city. We have flock cameras up. So this whole thing about somehow people's rights are being violated by the utilization of drones by the Division of Police, I don't know where these crackpots come up with this stuff, quite frankly. I don't get it. We have every right to protect our citizens and to protect our men and women in blue. And for these constant attacks being directed against the police, the council, in general, by these nuts that don't even live in the city, is beyond me. But my patience is gone, and my diplomacy is gone with them. So they can
So
say
to the-
what they want.
To the chair, I won't comment on that
yeah.
portion, but I will comment just on drones in general. Is if the community sees even news stations are turning to drones for reporting.
Exactly.
So you see that they're covering a lot of their stories with drones, with the drone footage.
Right.
And there's private citizens have the same capabilities.
My
for
son
drone
has
footage.
a drone.
Yeah.
Okay, I mean, the whole discussion is an absurdity, and so we're all at the point where we've got to support our men and women in blue, support our neighborhoods. In Detroit, they're using them for even housing inspections, in correlation with other divisions and departments.
Well,
I mean, come on.
in New York, they're using them as a first responder.
There you go. I mean, there you go.
They're setting them in
I
place
mean,
of officers.
So, okay, my last question is this. We know that the federal monitor, who was here, there was an issue over at the casino. It's been highly reported. There's been comments made. The question I posed to the safety director, and I've yet to receive the information, was the casino, when there was a interaction with the federal monitor, Mr. Racine, that there was a request, there was a call made for CPD to respond. Because the officers working off-duty at the casino do not have body cams, correct?
Correct.
Correct. The question posed to my office was, how long did it take the police working in the downtown area to respond to the casino? Because when they did respond, from what I was told, that Mr. Racine had already left the scene. Do we know what that time frame was?
To the chair, this is not a call for service that we've looked into.
Okay.
In the past, as my comments on this, I was made aware of an incident that occurred.
Yes.
At that time or on the following day.
Yes.
But it didn't rise to the level of an
Okay.
investigation.
Yes.
Just based on the facts that were stated to me. From my understanding, is the call was canceled by the off-duty officer, but I will
Okay.
verify.
So they never did. They never did arrive at the casino.
I will verify if
Let me
they
know.
actually went out.
Okay.
But we can verify that time.
Because
for you.
I've asked that to the director. I've asked for that information. So it's just all about transparency. It's all about clarity here. That I want to make sure that I want to know what that time lag was, and if that call was dispensed with, was called off, then let me please notify. So
I'll have that for you today.
I'm making that officially through staff, through the acting director, and through your office. Okay. I thank you for we have two people who are here, but my colleagues, Councilman Slife.
Yes. Two quick things, and one to piggyback on the drones. Once again, I will just state into the record, because it's very clear that there are individuals who are concerned that the Division of Police would use drones to basically track and target people exercising their First Amendment rights at events. We are seeking to use drones to track people and monitor for illegal activity at otherwise constitutionally protected public events. If you are coming to a constitutionally protected event to exercise your right to free speech, that is not illegal activity. Engaging in criminal activity
That's right.
at that is criminal. And if you are coming to engage in civil disobedience, which inherently is illegal, there are consequences to that. Great things have happened in this country due to civil disobedience. I'm not disputing people's decision whether they choose to engage in it. However, there are logical consequences to that. So that's one. Two, I want to just specifically address, because I want it to be clear to people, council's passing legislation to ratify the CPPA agreement is not merely a precedent or a tradition. Under state law, this body is not a party to that agreement. The residents of the city of Cleveland are not a party to that agreement. Under revised code, and it was just sent to me, 4117.10B, we are required to accept the negotiated agreement between the executive branch of government and the employees in that collective bargaining unit.
That's right.
This is common for every other collective bargaining unit
Right.
as well. And if we were to hold it, and if we were to try to modify what has been collectively bargained between employees and their employer, we would be beyond the bounds of our governmental authority.
That's
So
right.
this is not merely something that we are rushing through. This is a requirement under state law that we ratify what has been collectively bargained between employees and their employer.
And I-
So I think it's important because the implication is that we are, that there's a dereliction of duty
No.
in understanding we do not have that legal authority. I am not an attorney, but I also would submit that the Cleveland Police Commission does not have that authority to intervene on a collective bargaining agreement between employees and their employer.
And I've indicated that to the CPC, that this is, as you just outlined, this is a state issue, a state requirement. Collective bargaining is governed by the state of Ohio, not by Cleveland City Council. So again, we took the appropriate action that we were required and mandated to do. We did that. Again, we do not negotiate. That is purely under the auspices of the administration, and negotiate contracts, as you've indicated, with all the bargaining units. And then they come before City Council for a vote for ratification. Councilman Casey.
Thank you, Mr. Chairman. Mr. Chairman, to the chief, an off-duty police officer working a second job does not have to wear a body cam, correct?
Through the chair to Councilman Casey, that's correct. He does
And-
not have to.
And that's per the bargaining agreement as well, too, correct?
Through the chair to Councilman Casey, that is something that does require negotiations.
Okay, thank you.
Thank you. Yep. Okay. Any other questions? We have two citizens that are here. Chief and Director, if you would go to the ends, because I don't know if there's something that you may want to respond to after the fact. But Ms. Pamela Pinkney was the first one who signed up, Reverend Pamela Pinkney, and you will be allotted your 3 minutes as soon as you are seated and prepared. And you tell me when. You push the button down and bring it up close, and you tell me when you're ready to begin, and I will start the timer.
Good morning.
Thank you.
I was ready. I'm glad you tabled that. And pastors really love you right now. That's one of the things that we don't want to function on is emotional decisions.
Yes.
Another reason I like that legislation table is because I'm going to state again, there are no women of color in leadership in law enforcement in the city of Cleveland. The chief, the director, all of them are either black males or white people, and we need people of color in these leadership positions. I wasn't even going to say this until you said something earlier. I just want to let you know that when the public comes and has expectations of you, it's not because of their age or even ignorance, it's because of not an understanding. I'm aware that you don't hire and fire, but you do have the authority, like what you just did, tabled that legislation.
Yes.
You do have the authority to not allocate funding when decisions are not being made adequately for you.
It's not, please. Thank you.
For your residents. And I would usher you and urge you to continue doing that. I came today not because I wanted something, but I wanted to make a statement for people who are watching you all at this table, to let people know that you are not our enemies. You are working real hard to make our city safe. You are working real hard to have the betterment and the welfare of our city in your hands and in our lives.
Right.
And I appreciate that. And I didn't come here to attack your character or attack your decision-making or anything along those lines, but I believe a discussion needs to take place between law enforcement and citizens. It could be held at the, what's that arena over by the college, whatever it's called.
Wolstein Center?
Wolstein Center
Okay.
or some type. There needs to be a conversation. There should not be a time when people should be afraid of the police and afraid of the people. I'm glad that you have a summer plan in place.
Yeah.
I heard the drones. I'd like to know what else is in place. And I'd like to know what is the recidivism rate for incarceration with what you have in place for black, brown, multiracial, and females, and just people in general. What is the recidivism rate for what you're talking about, the squatters and that type of thing? Because if we can end homelessness, we can end a lot of your situation. And I thank you for your time and
Thank
your
you.
attention.
Thank you.
And I agree with every comment that was made by council. And I want the gentleman who left know that these are people, these are not experiments.
Yeah.
And anytime you have money and you have people, the court and the church will always be involved.
Thank you.
Thank you.
And you kept your time. I thank you very much. And I would just
As a
say
preacher,
before you
how about that?
leave the table, see, you understand that council does not hire, does not fire, does not administer, does not deploy. But as you've been in attendance, you see we have people coming down here that are just pounding on the council who do not understand at all how
Well, my
government
challenge with
functions.
that is, like the people who came down and destroyed our
Yeah.
city hall,
Yeah.
they don't even live in Cleveland.
There you go.
They're wealthy and their parents can bail them out. And they're coming down here destroying our city
Yep.
on our watch. And then also, ignorance is bliss.
Yep.
And I'm not, ignorance means that you don't know. But I think that people need to be educated and taught what legislation can do, will do, and would be interested in doing. Because when you table something, that puts something off and makes
Right.
people have to come back with their answers. And they do need data. We need data because it's time out for all this folks getting killed in the name of the law and in the
Thank you.
name of religion.
Thank you, Pastor.
Thank you. You're welcome.
Our next speaker is Lou. And Lou, when you're ready to speak, the time will go on, just like we do for members of the
Hey,
city
good
council.
afternoon, everybody.
Thank you.
First, I want to show that my appreciation to Councilman Casey. It's really a good thing that council member would not want to vote for something which is not clearly playing out to the benefits of our residents. Of course, city council members will not keep yourself ignorant about the issue. That's why you keep asking good questions. That's the important part of coming to these meetings, so people can actually learn the government sometimes has to make hard decisions. Yes, sometimes the result will look like the government is against people, but sometimes it's also helping people. So each member should be learning lots of things at the same time. The citizens, the residents should learn too. So for the nuisance, that part of this discussion, please understand, from the past, the whole Cuyahoga County, not only city of Cleveland, this nuisance issue has caused lots of domestic violence victims losing housing. Because now we are even in the bigger danger, as Councilman Richard Starr pointed out. The definition is broad. Any of these situations can happen in private residential places and also public spaces. You always have bystanders who do not understand the situation, helpfully calling police.
Yes.
But they did not understand this is domestic violence. They call that as a nuisance, as like a property damage from that point of view. However, lots of the victims will be triple victimized because of these situations. Out-of-state landlord and also the in-state landlord, doesn't matter which landlord, lots of times they will really shift the responsibility. If there's a fine occur, they will shift it to the tenant. So now this tenant gets trouble financially, location being damaged, it's bad for the residents themselves.
Yes.
However, the crazy stalkers or abusive exes are still coming to harass them. Some of them even have children already. So this is really a public safety issue and also a societal issue as well. On the other hand, harsh summer and harsh winters both exist in Cleveland. However, I'm so disappointed to remind you guys, if we do not strengthen all these components, lots of people forcing to be homeless, to be unhoused, will still have a problem to be the scapegoats for our public safety issues as well. Just like people will have a problem with the drone, no matter if it's good or bad to our community.
Thank you.
Thank you very much.
Thank you for your comments. And just as I'm sure you heard that the administration, public safety, this domestic violence is not a part of this legislation. That's so just so you're aware of that. It's
To
not
the
a
chair,
part. Yes, Chief.
if I can just say
Yes.
really quickly, victims of crime are not a part of this.
That's exactly.
It's whether that be domestic violence or someone who has been a crime victim. This is not what
But
this.
lots of time,
Not what
they
this is.
are known as a victim after the incident, after certain parts of
Okay.
the incident already go into some kind of other procedures.
Okay.
That's why they
Okay.
are very easily to be triple victimized.
Okay,
And-
and we appreciate
Yep.
those comments, and that's why, it was City Council, to the viewing public, it was City Council who fought so hard over the years to create the domestic violence unit within the Division of Police. We're very much aware of that. So again, working with you have two females here, the Assistant Safety Director and Chief of Police, who is very mindful of making sure that we do not create additional victimization of people who are being victimized, okay?
But for the male council members here, I'm not very sure if you are aware of these things.
We're aware of that's why it's in
why
there.
I will
Yeah.
offer the information.
Thank you. Thank you, Lou. Thank you very
And
much.
also, people are disappointed about the drone policy written by somebody working only behind the doors
Okay.
without showing that to the public.
Thank you.
Thank you very
Thank you
much.
very much. Without any additional questions, I want to thank the Assistant Safety Director for being here, the Chief of Police, all members of the City Council, our public speakers. This committee stands adjourned. Thank you. Yep. Yeah, right.
We're out before 2.
Yeah.
So you know what I'm talking about, right? He lives in Bedford Heights. I don't mind he coming to a police commission meeting because when police do the work, you don't do the work isolated. But when he comes to city council,